Hello, everyone, and welcome to Inform New Hampshire. My name is Dean. My co-host Richie over here to my right, and then we have Danny Richards here to debate today. We have another debate partner that we hope will be here soon, and we're going to walk him right onto the stage if he shows up. Otherwise, we will have a dialogue with Danny Richards about common law today. So this is Inform New Hampshire. We have a YouTube channel called Inform New Hampshire. We hope you'll stop by. Click the like button, subscribe if you will. We also have a Facebook Facebook group, which is also called Inform New Hampshire, and you're welcome to go there. Richie and I, about a year ago, started this show. We were very concerned with the direction of our country. More importantly, we were very overwhelmed by some of the hidden and secret information that was out there and available, but would never show up in the mainstream media. So we're here to report on and to comment on news and information that you will not get from the mainstream media. We always start our show with a tribute to our friend Jerry DeLemus. He is imprisoned in Nevada right now. His wife Susan DeLemus was on the show last week. She's a former state representative for the state of New Hampshire. Very gracious lady, but Jerry was kidnapped by the FBI. He was charged with a number of false charges that he wasn't even in the state during the time that they made those charges against him for the incidents. So it's a ridiculous situation for him to be in. It's a criminal operation that's holding him out there, and we all think the FBI is a pristine law enforcement agency, when in fact it's a private corporation that is running a criminal operation within our country, shouldn't even have jurisdiction in our states. And so it was an unlawful operation for them to come in and take him away from New Hampshire the way they did as a SWAT team. He simply would have easily surrendered to them. He was in communication with them anyway. I'm getting a little long-winded about it, but I'm going to turn it over to Richie. You want to comment on that?
Yeah, I actually have an update for you. Jerry had a hearing. Well, actually, he went into court last Friday to issue a new plea, if that's the correct terminology. And the judge told him no. They're accepting the guilty plea that he first rendered. So they're going to sentence him on May 31st. And this is a guy who he entered the plea of guilty to protect friends of his who were being threatened by the FBI and intimidated, and all kinds of garbage was going on. He was looking out for his friends when he did it. Because of that, he might sit in jail for another year, 2 years, 3 years, who knows. This is the Judge Navarro who said the Constitution won't be used in my court. She should be tried for treason and hanged. And if that ever happens, somebody in Nevada, contact me, I'll provide the rope. Anyway, it's a travesty of justice. Harry Reid and Clinton and people like them should be in prison. Get these innocent people out of there and put the guilty ones in. That's what's supposed to happen. If you want to help out Jerry, his plight is obviously worsened now with the situation, and sue. You can go to freejerrydelemus.com and contribute if you have some money, $5, $10, $20, whatever you can afford. Always keep them in your prayers. They can always use those. We were supposed to have a debate today. I'm a little disappointed right now. I'm hoping that Dan Itse, state representative, is just late and has difficulty with traffic. But if he doesn't show up, we're going to continue to have a discussion on this, because this is the most important thing for Americans to know about. It can save this country, and I mean that quite literally. With that, we have Dan Richards here with us to my left.
No S. Dan Richard.
Dan Richard. Well, excuse me, I'm an American. What can I say? Dan is an entrepreneur. He's the owner of Alpha Dog Training, world-class dog trainer and breeder out of, is it Barnstead, Dan?
Barnstead,
yeah. And he was going to debate Dan Itse, the state rep, on these issues, but we're going to ask these questions of Dan, and he can answer them, because it was going to be a debate to just be one-sided now, that's all. Until, if Dan Itse shows up, we'll pick it up where we're at. But for right now, if, Dean, you want to start the questions?
Sure do.
Before we get started, I'd like to add something, too, about hopefully Dan being here today. I wanted to encourage everyone to do what we're doing now, which is to reach out to our state reps. I met with my 2 local reps last week, and this type of dialogue needs to start happening on a regular basis, because these men and women, even if they have differences of opinion, still are there doing a public service for all of us, And it is the lack of communication between ourselves and our reps that is a huge part of the apathy that has become, it's out of control. It's out of control. There's no real understanding. You know, they swear an oath, people at all levels of government swear an oath to defend the Constitution against all enemies, both foreign and domestic, yet they don't even know what the documents say at the state or the federal level. So with that, again, I wanted to thank you for the opportunity.
Love having you here. Glad you're here. Thanks. So first question is, please explain what common law is.
Common law is the evolution of the British system of adjudicating issues. It began with the 1100 Charter of Liberties. And for those who don't know Chris Ann Hall, that you folks have had brought in, she's absolutely brilliant. Her resources are excellent for giving you a comprehensive overview of the 8 centuries that had passed at the time of the writing and ratification of our constitutions of the practice of the common law.
Exactly. Let me just mention, Chris Ann Hall has a fantastic video called Genealogy of the Constitution, where she runs through this stuff. So yeah.
So the common law was developed within the realm of the English society, and it basically revolved around this basic premise. The free noblemen of the realm of England were sick and tired of the king making things up and deciding to arrest and try these people for bogus crimes. So they put a sword through his throat and said, hey, you're going to knock this off and we'll let you live. We're willing to live by whatever, if you come up with rules or regulations or statutes, no problem. You have to convince a jury of our peers, which is where the Magna Carta in 1215 all comes from. So this is all the evolution, really, of the Magna Carta. And each country that adopts this form of common law process always does so within their realm. And we'll explain that in more detail as we go along.
Excellent. All right, next question is, explain what a court of record is and what jurisdiction it has.
Court of record is the location where common law procedure and common law proceedings will happen under common law. The court of record, as listed, I'll read from Black's Law, 5th edition. A court of record is a judicial tribunal having the attributes and exercising functions independently of the person or of the magistrate designated generally to hold it. And it proceeds according to the course of the common law. It acts, and the proceedings being enrolled for perpetual memorial. The other factor is that there's normally a seal, and again, it proceeds in the course of the common law, which is critical if you're going to hear matters that are common law related. Other factors on the court of record from a historical perspective that's very important. Chief Justice John Marshall in 1830, ex parte versus Watkins, made this pronouncement from the Supreme Court of the United States from the bench. He was the Chief Justice. The judgment of a court of record whose jurisdiction is final is as conclusive on all the world as a judgment of this court would be. It is as conclusive on this court as it is on other courts. It puts an end to the inquiry concerning the fact by deciding it. Now, the reason that's such a powerful part of our history is that it shows what the founding generation was thinking, what they actually agreed to with having a common law and a court of record to adjudicate all matters. And to take that one step further, we have a excellent New Hampshire case law, 1837, State versus Rollins. And in there, it gets into the very specific details pertaining to the adaptation of the founding generation, of the adaptation of the common law system and their courts of record. And let me read briefly from an outtake from this case law, which, by the way, was recently cited as recently as 6 weeks ago or March 10th, whatever that timeline is.
Yeah.
In a recent New Hampshire Supreme Court case. It was also recently cited, I believe, in 2006 in the case versus a member of the New Hampshire Bar was making the case of someone trying to operate or to practice law without being a member of the bar. And he cites this case as well because he's citing the historical record, the public record on the court of record in the common law. So let me read that to you real quick. The commission constituting a president and a council, sidebar, president and council, of course, this was written at the time before the Declaration of before the federal Constitution. So the governor of New Hampshire was actually the president of New Hampshire. To take care of the said tract of land called the province of New Hampshire, and of the planters and of the inhabitants thereof, and to order, rule, and govern the same, made the president and the council and their successors a court of record for the administration of all justice in all cases, in quotes, as well criminal as civil, with full power to give judgment and award execution, so always that the forms of the proceedings in such cases and the judgment thereupon to be given. Within that same case ruling is another section that is actually the law, and it makes this a very important statement. In this state of things, the Constitution was adopted in 1783, containing the provision relied on by the defendant, that all laws which have been heretofore been adopted, used, and approved in the province, colony, or state of New Hampshire are usually practiced on in the courts of law and shall remain and be in full force until altered or repealed by the legislature. Such part thereof only excepted as they are repugnant to the rights and liberties contained in this Constitution. Now, it talks about the trial is all about the abduction of a 6-year-old slave child, black child, that was taken and was being sold to Alabama. Mm-hmm. And what's really ironic about the case is that the defense attorney was making the case that New Hampshire had yet to hear from its inception in 1783 with the adaptation of the state constitution. It had yet to hear a kidnapping case. So there was no kidnapping case on the books.
Precedents.
Exactly. And so what is very unique about the court of record and the common law that is completely different than our current legal system is this. The Magna Carta is the regulator by which the requirement in Article 35 of the State Constitution Bill of Rights that requires that there be an impartial interpretation of the law. So when the king, substitute for, if you will, for a second, king, parliament, legislature, regardless of the institution, when they pass a statute, code, or regulation, or, quote, law, they first must pass muster. In other words, it is the jury trial process that produces the law. Someone files a claim in a common law process when they file their plea in the rules of common law. That produces an investigation. The grand jury, the first thing it does is answer questions of law. Is the law righteous? If someone comes up with the idea that pink shoes should be a felony, well, you're not likely to find 25 of your neighbors in a grand jury to go along with you that pink shoes are a wonderful law.
Hence, they would strike it down, right?
Exactly.
Yep.
What they're offering us today is jury nullification. But that's a substitute in a different jurisdiction. It's not the common law jurisdiction. Under common law, we, the people, decide what is law and what is not. If there is sufficient evidence of the grand jury that such a crime is in fact, someone has been wronged, someone has been harmed or damaged, right? The next thing is they will hear whether there's sufficient evidence to indict the person of the crime being alleged. The next process, of course, is a trial by jury. So you have a grand jury and a trial by jury that decide what is law, what is the punishment, and that is the regulator. That is part of our state constitution. These are the things that are guaranteed to us in our Bill of Rights. This is still the law of the land. It's never been repealed. And on that note, by the way, folks, go to the state constitution and take a look in multiple places. You will see that the state has no problem using the word repealed when it has constitutionally repealed something, and then amend when it has amended something. So it is well capable of, but we're dealing with extra constitutional additions of 72A, 73A, which are judicial issues. We'll get into that later.
So you,
I got to say
ahead.
something here, though, because, well, let me say this to the people out there listening. I've heard people in a courtroom ask the judge, is this a court of record? And the judge will say, yes, this is being recorded. And people accept the fact that that's a court of record. It is not a court of record. There are 4 criteria to be met to constitute a court of record. Danny mentioned 2. I don't know if you want to mention the other 2, Dan. You said sometimes it has a seal.
Right? Has the
And-
power to impose fines for contempt.
Yep.
And the biggest one really are the 2 major issues is that the magistrate is independent of the tribunal. In other words, it's we the people who adjudicate the issues. The judge, and again, go back to the state constitution. This is where the references of magistrate, because the judicial authority granted to lawyers in this state under the state constitution are quite limited. The judicial portion of the state constitution is quite short. It begins with 73 and only grants the state jurisdiction in equity in issues of probate, divorce court, and small claims below $100. That's the limit of the scope of the judicial power of the state. So when they deal with issues of common law, it deals with all of those issues. All civil and criminal procedure is done in the common law.
In a court of record.
In a court of record, and it is the law of our state. Again, it's still on the books.
It hasn't substituted the New Hampshire Constitution for any other law that I'm aware of.
None whatsoever. And by the way, it's strictly prohibited that we be subject to any other laws other than that of the common law, which is Article 12.
now I've never heard anybody. This is the first time I've heard of jury nullification being a substitute for a different jurisdiction. Is that what you said?
Yes.
Can you explain that?
Yeah, the jury nullification, we currently have a completely illegal criminal, let me come right out and say it.
Apparatus.
The entire New Hampshire judiciary is guilty of treason against we the people. They are depriving us of our rights under the federal statute, and that is deprivation of rights under the color of law. And they've conspired with other members of the legislature and at a federal level to deprive us of our rightful common law jurisdiction. This isn't my opinion. These are the facts that are on the books. Mm-hmm. So their ability to create an entire different jurisdiction is not founded in anywhere. Where do you come up with it? The federal constitution is quite clear on the judicial power. Article 3, Section 2 under the judicial power makes it very clear there are 3 jurisdictions. One is the common law, courts of equity, and admiralty jurisdiction. Those are the 3 jurisdictions. So in the state constitution, the 38 articles making up our Bill of Rights is the common law. That's one jurisdiction gone. The second one is delegated to the Articles of Confederation when we made the Union to fight the Revolutionary War. So we delegated admiralty issues to that body. And then, of course, they were acquiesced, of course, when the federal Constitution took over to deal with the shortcomings of the Articles of Confederation. Either way, admiralty jurisdiction is delegated. The only remaining jurisdiction left is courts of equity. And the state constitution is quite clear. They're spelled right out. There's 3 granted powers to a justice of the peace who gets a 5-year tenure as long as he maintains in good behavior. And his primary jurisdiction is that of equity courts, only civil in nature, to deal with probate, deal with divorce and marriage, and small claims.
So what would you call the equivalent of jury nullification in common law?
Well, jury nullification is a feature and benefit that they wish to offer us in a foreign jurisdiction.
Okay.
Right now, the current function of the existing jurisdiction, they claim, the state claims to get there by bypassing the primary directive to create a court of record in Article 4, form of government, to the second part, Part 2, other courts. There's only one problem. There's no authority for any additional jurisdiction, which is based in applying the law of merchant or admiralty code into the state legislature and passed along that route so that it offers you, see, those rules of procedure under admiralty, this is where jury nullification would be a feature and benefit under a foreign jurisdiction.
Okay.
which is what it
But
is.
otherwise,
Yeah.
in common law, the jury creates the law based on their verdict?
Exactly.
They decide fact and law.
Right.
Yeah.
Right. Questions of law and issues of fact are the primary function. This is the way we decide
sounds
that we,
like-
the people, don't get bad law.
It sounds like jury nullification was created, in my head, it sounds like, to continue the cover-up of that they
The
made,
deception.
they made the deception
Exactly,
that
yeah.
they made a new jurisdiction and put us in it.
The
Exactly.
people who conspired to do this have done exactly that.
Yeah.
Very intelligent attorneys have reviewed our Constitution, and they've offered us substitutes. All of this is to offer us a substitute service, which, by the way, we get to pay for, which is a violation of Article 14, which states quite clearly all legal procedure in proceedings in the state of New Hampshire is to be free, complete, prompt, and in conformity to the law. And I mean the common law, not statutes and codes.
Okay. So,
Let me just say something. here,
please
Dean,
do,
if
go
you don't
ahead.
mind.
Yep.
I wanted to say something about this debate. I invited Dan Itse and Dan Richard, because I respect both of their opinions. And I happen to believe that this is still America, so if you disagree with one another, that's okay. What I wanted to tell you at the beginning of this is that we were going to announce a winner at the end. And we will announce a winner, because there's going to be one. And I'll tell you at the end of the show. But it's unfortunate that Dan didn't show up. I sincerely wish he did. You know, we picked him up a beverage so that he would be comfortable. I have no animosity towards anybody other than the people that are running our state. I just wanted to say that anyway, so I'll turn it back. I think it's important.
All right, thank you, Richie. On to the next question, and thank you, Richie, for coming up with these questions. So Article 7, which is the Bill of Rights in our state constitution, under the state constitution, Article 7, who are the sovereigns and what jurisdiction do they normally fall under?
That's an excellent question that the judge in Dick Marple's case did not answer. He made that comment,
yep.
excuse me, and I was dumbfounded to hear a member of our judicial branch. By the way, now that's on the top of my mind, I'm going to make a recommendation that we recommend adding this particular piece of legislation, which would be the education and what's the word? The education
Come on
and
in.
consent statute.
Right over here. Welcome.
Yeah.
All right, just walk right there. You got it. All right.
Sorry
Have a
about
seat,
that,
Dan.
gentlemen.
Dan,
That's
it's
all right.
welcome to
I
Inform New
spent the last
Hampshire,
15
Dan.
minutes down on your doorstep because I didn't realize it's the fourth floor.
Okay. All right. Well, welcome. We're glad
Welcome,
you're
Dan.
here.
I'm glad
Yep.
you could make it too.
So we've gone over a few things. We've talked a little bit about common law. What is common law? We've talked about court of record. What is court of record? So we'll give you a chance to say a few things, because what we did was we designed this to have a few questions
Right.
that each of you would respond to, and we would rotate the first and the second response.
Pleasure to
time.
meet you,
Let
by
me-
the way, sir.
Yes.
Yep.
Nice
Yeah,
to
let
meet
me
you.
let me
Shake
say
hands
this.
after.
For people who don't know Dan, this is Dan Itse. He's a state representative out of the Fremont area. You're an engineer too, also.
Yes, I am.
An engineer. And I'll say what I wanted to say earlier, and that is that I invited both of these gentlemen to the show. We did, me and Dean, because we respect both of them. They're intelligent men. They've researched a lot of these issues. There's some disagreement among the two, and I'm not here to pick sides, because I'm not going to do that. The judge is going to be the listeners out there. What we would like you to do is think, critical think about what it means to you, because this is your law, this is your government, your country, your life. You're living now. Someday you won't be. Take an active part in it. So we'll let Dan answer the few questions that Danny already went through, if that's all right.
And by the way, I'd like to ask Dan an important question for the viewers, which is, I came into my research from a different perspective. Would you share with the audience your perspective, because you've been a dedicated public servant, and again, thank you for that. So share with us kind of how you've come into the legislature, and so that we all have an understanding of that.
Well, I came into the legislature originally because of my antipathy toward the manner in which the state was involving itself in families. I mean, that was my purpose for entering the legislature. I got my first real corrective piece of legislation through after about 6 years. Things moved slowly in the legislature, which was to, well, what I perceived after being in there really was that they had managed to circumvent the constitutional protections that you would anticipate by moving child protection out of criminal law and into civil law. So instead of requiring beyond reasonable doubt, you require preponderance of the evidence. They walked around all the requirements for warrants and all those protections you would expect for a crime, someone accused of a crime. And what I was able to get instituted was a series of due process for child protection, or those accused of abuse and neglect, that when they come to where the government, they have to tell you that you don't have to let them enter your house unless they have a court order. Now, it's not a warrant, but it's the same, practically speaking, it's the same threshold. Because they have to have gone to a judge, and the judge has to have said, yeah, there's some reason to go in there. They can no longer surprise you with evidence. You have to have 5 business days. All evidence to a hearing has to be introduced 5 business days before the hearing so that you have opportunity for discovery. I mean, just real basic kind of stuff. It was fun in a sense because it was the first time I really played the legislative game. I went in. I originally went in and I said I want to increase the threshold for finding somebody a founded case from preponderance to clear and convincing evidence. And after a lot of testimony, it was clear that wasn't going to happen. The then chairman pulled me aside, and it's against the rules of the House for you to chair a subcommittee on your own bill, but he made me chairman regardless. And he said, find a different way to do it. So I came up with, I realized that the only way to do this was through due process. And so I came up with 5 issues of due process. And I knew the ones, there were 3 that I really wanted. And so we got to the subcommittee hearing, and I threw my discard. And we got to the committee executive session, and I threw my discard. And but when all was said and done, we had then a further negotiation with the Senate, and I threw my discard there. And at the end of the day, everybody said, "Whoa, we took this bad piece of legislation and we depowered it. We got it all cleaned up." And I said, "Mm-hmm." But then after that, I said, "Okay, Lord, you got me here. I've at least at this moment, I've accomplished what I set out to do. You're going to have to give me something else to do."
Right.
And that summer, it was 2006, it was an election year, and we had the brouhaha of the courts saying that the order of names on the ballot was unconstitutional, that we couldn't start with the letter A because the people of New Hampshire were just too dumb to figure out where their candidate was in an alphabetical list. And they said there was this thing called primacy, that the guy on the top of the list gets voted for more than the guy on the bottom of the list.
Is that the guy that has the most money to donate to the...
No, it's the guy whose name began with an A. And so I'm an engineer, right? So I went through, and first thing I did was we had a number of elections where we had constituent or multi-candidate rep races, large districts. And I just looked for primacy. Was there any primacy? And the answer was no. There wasn't any primacy, and if there was anything, it was actually best to be in the middle of the pack, not on either end. And both ends were pretty much equal. And but then I read the Constitution, and I came up with I found Part 1, Article 29. Article 29. That's Part 2. And Part 1, Article 29 says, "The power of suspending the laws or the execution of them ought never to be exercised but by the legislature, or by authority derived therefrom to be exercised in such particular cases as only the legislature shall provide for. So does the judiciary have the power to tell the Secretary of State to not execute the law as we told him to? No. And so I made the arguments that we needed to call ourselves into session and tell the Secretary of State to do it the way we said, which is actually what he wanted. And my arguments were adequate, that both chambers of the legislature were convinced to call themselves into session. And the Senate passed an order directing the Secretary of State to do what we said. Unfortunately, I couldn't be there that day. I had to be away on other important business. I had a client out in Ohio. And I hope I would have had the clarity of mind to say no. But they amended the Senate's order with words from my emails as a preamble. And the Senate had already adjourned themselves, and they weren't there to concur with the amendment, and so everything failed. But as a result, one of my mentors said, "You've made these grand arguments on this single article of the Constitution. You ought to write an article. You ought to write a commentary on the Constitution." And I said, "You really think so?" He said, "Yeah." I said, "Okay." But that forced me to go through every article of the Constitution and figure out something to say about it. And I found a...
It's fascinating, isn't it?
I found what I believe to be the best articulation of American liberty, bar none, in the Constitution of the state of New Hampshire. There is none other that compares to it.
Well, let's get to it. Here we go. You ready?
Mm-hmm.
All right, so please explain what common law is.
Well, common law...
In America.
Common law, yeah, well, common law is, as the dictionary of the time says, those customs which have been practiced so that, let's see, customs which by long prescription obtained the force of laws. So it's basically what we as a society all agree to as the law of the land. It's unwritten, but we all know what's right and what's wrong. If you were in a Muslim country, the common law would be Sharia, but not here. The problem that, as I see it, that we really have, and this is integral to where we are as a society, is I do not believe that we in fact have common law. When half of the country says that it is under certain circumstances permissible to take innocent human life, and the other half says it isn't, you don't have common law. You don't have a law in common. When half of us know that you obtain property by labor or by gift, and the other half says that when a poor man is starving, he has a right to steal, and particularly if he can use the government as his agency of theft, is permissible, then you don't have common law. And so we have a real problem in relying simply on common law, because we as a society don't have a common law.
Okay. What about, can you explain what a court of record is and what jurisdiction it has?
Well, we do have, and this is a court of record historically, and I went back and I have access to something you guys don't. I have legislative research. And I asked one of our legislative researchers to get me the law, a law from before the state of New Hampshire, i.e. when we were a province. And it's actually interesting because it's 1769, and it actually deals with the creation of the counties as well. But in that, it delineates the court structure. And as best as I can tell, because they didn't really actually have something called a probate court. They had a court of general pleas, which employed, as best as I can tell, both judges of probate and justices of the peace. And the justices of the peace also had the duty for raising the money for maintenance of the courts. Associated with them were the Register of Deeds and the Registers of Probate, which we still have, sort of. And so if you look at the transfer of property in particular, there are two ways it's done. One is by sale, which is the record is kept, court of record. The record is kept by the Register of Deeds. The other is by inheritance or will, which is kept by the Register of Probate. Register of Probate also deals with all family records, adoptions, guardianships, all those kinds of things. As far as general jurisdiction would be a court that can handle any matter. It's not restricted in what it handles. In that sense, right now in New Hampshire we have one court of general jurisdiction. That would be the Superior Court. Superior Court handles all sorts of matters according to the rules of the lower court that would ordinarily handle it. So when it's handling a probate matter, it handles it according to the statutes controlling the probate courts. If it's holding a criminal case, it holds it according to the statutes regarding criminal law. Torts, same thing. The thing that sets the Superior Court apart is that it is a jury court as opposed to the lower courts. Now, the one thing I want to apprise you of is we are at a very interesting juncture of New Hampshire history, and you guys have an awesome opportunity. In 2012, we created something called the circuit courts, and it was promoted by the courts to make everything more efficient and the wheels of government grind people more quickly.
Grind is a good word.
But
Sorry.
that was intentional. But what happened inadvertently is we replaced the constitutional probate court with a legislative probate court. This was realized about 2 years ago by your Secretary of State. He's probably your biggest advocate in all of these matters. He actually holds all the records of all the probate records from the 16 and 1700s up through in the 1800s, and then they're still after that in the local courts. One of the things that happened is after this change occurred, the judges of probate, one of the things that a register of probate does is he or she acts in the same capacity that a clerk of courts would in the other courts. But instead, they're elected by the people. Then, after this change in 2012, the judges of the probate courts began employing their own clerks and locking the probate registers of probate out of their offices. This caused a bill to be put in by Senator, I can't think of his name, from Rochester, Senator Gray, that would reinstitute the probate courts as constitutional courts. Same time, this last session, a bill was put in by Senator Carson, a proposed constitutional amendment to remove probate courts or references to the probate out of the Constitution, in essence to get rid of constitutional probate courts. Now, what we did in the House is went to the Judiciary Committee. I'm a co-sponsor of the bill to reconstitute the constitutional probate courts. It was retained, which means they'll work on it over the summer, and it will be one of the first bills out next January to the floor. We deal with all those bills the first session day of next session.
Okay, so we'll follow up on that.
But this is important because you guys have a real interest in this. The constitutional amendment to get rid of the constitutional probate courts failed miserably, which is why they retained the other bill. Because now it has to be untangled and the probate courts have to be put to rights.
Okay.
All right, well,
Like, can I respond to, because Dan missed the beginning on Court of Record, I wanted to come back on and explain just a little bit differently. I sent you that case law from State versus Rollins in 1837.
Yes. That is a fascinating thing.
And the case in great specificity spells out all the legal questions pertaining to...
Can you point me to that in the case?
Yes.
I did peruse it, but it doesn't mean I didn't miss it, because I picked up on other things,
Okay.
which are near and dear to your hearts.
All right. First one I reviewed was the issue of the very first thing they did when they convened the first legislature was to create a court of record. And this is on page 561, quite a ways in.
560. Page 561. I don't have this. My page is the same way.
Okay,
But
well,
bear with me, because I'll
Okay.
kind of go
let
through
me,
it. Richard.
yeah, I'm just going to ask you guys, because we're going to run out of time. So
Yeah, but you got a
you can
bunch of
keep it
walks
to
on your
like
hands.
2-minute answers, guys, so we can get
Absolutely.
through this.
So I'll run through a quick sequence. Basically, the case had to deal with common law, court of record, and it dealt with all of the transitional issues from, we had the original state declaration after Governor Wentworth had to take off on
Right.
January 5th. Then we had the law that was written in here that dealt with retaining all the statutes
Yep.
and all of the laws, which is Article 90 in our state constitution.
Correct.
Says that we're going to keep all those things that are currently ongoing. And so...
Unless they're repugnant.
Exactly. And so there's no doubt throughout the writings, recently as of March 10th, New Hampshire Supreme Court, State versus Santa Maria, was that also quoted, State versus Rollins, as well as the New Hampshire Bar was defending itself against a gentleman who was practicing law without being admitted to the bar. So their defense counsel argued the same case. In other words, he was trying to access common law rights.
Yes.
And I agree with what you said earlier as well, too, about the common law not actually functioning. The tenets and the way common law, and we don't have time to repeat that since I covered it, but the common law system by which laws then evolve from the grand jury to the petite jury to then the legislature involving itself after the fact, once the people have decided that, I think it's important really to get to the point of when we read the New Hampshire Bill of Rights and their articles and we move to the second part. Second part, form of government, Article 4.
Yep.
The very first directive is to create courts of record. And I'll touch on this briefly because it was the point. A court of record for the administration of justice in all cases, as well as criminal as civil, with full power to give judgment and award execution, so always to the forms of proceedings in such cases and the judgment thereupon to be given. And
Okay.
on and on and on through there. The Yale Law Journal Review, one of my favorite reads, was written by Alton B. Parker, who was the Democratic nominee for president who lost to Roosevelt. And he wrote a brilliant dissertation for the Yale Law Journal in 1908 called The Jurisdiction of the Common Law Courts.
Yep.
And so all of
I've read
that
that.
shows quite clearly that there were the statutes of the realm of the territory of New Hampshire were adopted because the Magna Carta filter dealt with those if anyone was going to make a statute, it had to come from the Magna Carta process. So that's how statutes were adopted, and that's why the case law states that. So once we get into the second form of government, and when we talk about shall not be repugnant to what? What I did is I took and I broke down the Article 5 and broke it down into its 5 sections. It has 5 specific sections because as a corporate charter, each of those commas is another portion of the contract. Hang on. course, now I'm out of sequence.
Now, if we run out of time, you guys gonna come back next week? Because we're gonna run
Sure.
out of time.
Okay.
I mean, I say that
You're welcome
easily,
to.
but I've got to make sure that my schedule supports that. But that I would come back, yes.
Okay, here we go.
Well, we had a cancellation, so that might happen.
Pass that to Dan, because it's much easier to read
Read,
when you
I
separate all
understand.
the pieces, because it's such a long article, right? So the first thing I do is pay attention to, it's the 5th article after leaving the Bill of Rights. So we're supposed to create a court of record. And by the way, when you read Article 4 and the directive to create court of record, other courts aren't established. All we have is court of record, because it's actually functioning as usage and custom at the time. And all the civil and criminal issues spelled out in great specificity from all through the Bill of Rights are the common law jurisdiction. So that is what was functioning at the time. So when you go into the second part and you read the directive to write law, read what it says at the bottom. It's specifically addressing government. It's not addressing the people, because the only time Article 5 references the people, the inhabitants, if you go all the way down, is the capacity to tax us. We already have our own jurisdiction. The federal Constitution, when you go to the federal Constitution and you look at the judicial power, which was necessary because of the Constitution and who's going to have what jurisdiction. So Article 3, Section 2 of the federal Constitution says quite clearly there are only 3 jurisdictions: common law, equity law, and admiralty jurisdiction. So when we look at the state constitution from the lens of 1784, you have to remove 72A and 73A, because it didn't exist until 66 and 78 of this century or last century. So from that filter, you see that there is only the delegation of probate under the judicial articles, probate, the issues of equity, probate, divorce, and small claims. Admiralty jurisdiction was delegated to the Articles of Confederation and then onto the state constitution. That covered all 3 jurisdictions. There was no other jurisdiction. Now, other courts, I believe, is only a reference because, like you said, they then had to contend with how they would actually establish the equity and divorce civil proceedings. But the whole common law was covered, dealing with all civil and criminal matters for the sovereign people, the sovereign inhabitants that we cover under Article 7. So that's my long-winded commentary about, because I felt it was important for the sake of the debate that if we don't make sure that we're on the timeline of 1784, we can't know what was repugnant. So if the common law and the court of record, anything that violates that, in my opinion, is what is contrary and repugnant with the other jurisdiction that's been created. Floor is yours.
I'm gonna
Much time.
have to think about that long and hard.
12
I mean,
Sure,
I mean,
sure.
that's
You want to ask the next question then?
Sure. Want to get onto it? Article 7, Bill of Rights, the state constitution. Who are the sovereigns and what jurisdiction do they normally fall under? And that question is for Dan.
well, the sovereigns are the people. They're the ones that create the state. I mean, that's Article 7 is that the inhabitants of this state have the sole and exclusive right of governing themselves as a free, sovereign, and independent state, and
Herever after.
shall exercise every power, right, and jurisdiction pertaining thereto, which they have, unless, well, I'm going to have to paraphrase there, unless they have delegated it to the Congress of the United States.
Okay.
So, and looking at that 1784 lens, and I would broaden that to the 1776 lens as well.
Sure.
Is that the government of the United States doesn't have the power to create or destroy the state of New Hampshire. Only we do.
Right. Right.
And what power that state has is the power we give it.
It's true. It's true.
What about what jurisdiction does that fall under? Wait. What jurisdiction
Because
do they
in there
normally-
it does state specifically that the sovereign retain the right to choose what jurisdiction they wish to be adjudicated in. So in Dick Marple's case, when he claims that he's sovereign and she completely ignores him, and then and now is dealing with him in a general jurisdiction.
She being the judge.
She being the judge, right? So there is no authority for a general jurisdiction. If there is, I don't know where it comes from, because if we have the common law to cover civil and criminal, Admiralty delegated to federal, equity is the remaining court. In my opinion, it's a fabricated jurisdiction for a specific agenda that I'll get on to afterwards.
I
And so
generally concur.
and so from that section, since we're out of time, if you would give me just bear with me for this purpose. I want to read to you folks something, and I'm going to prove that this actually happened. This is Colonel House in the Woodrow Wilson administration. I gave you a copy right there for you, Dan. And this should scare every living American, because this did happen, and I'm going to show you the proof. Very soon, every American will be required to register their biological property in the national system designed to keep track of the people, and that will operate under the ancient system of pledging. By such methodology, we can compel people to submit to our agenda, which will affect our security as a chargeback for our fiat paper currency. For those of you who don't know what that is, it's Federal Reserve notes. Every American will be forced to register or suffer not being able to work or earn a living. They will be our chattel. We will hold the security interest over them forever by the operation of the law of merchant under the scheme of secured transactions. Americans, by unknowingly or unwittingly delivering their bills of lading to us, will be rendered bankrupt and insolvent, and forever to remain economic slaves through taxation secured by their pledges. They will be stripped of their rights and given commercial value designations to make us a profit, and they will be none the wiser, for not one man in a million could ever figure out our plans, and if by accident one or two would figure it out, we have an arsenal of plausible deniability. After all, this is the only logical way to fund government, by floating liens and debt to the registrants in the form of benefits and privileges. This will inevitably reap to us huge benefits beyond our wildest expectations and leave every American a contributor to this fraud, which we will call social insurance. This is 1913, by the way, folks.
Mm-hmm. When they set up the Federal Reserve.
Exactly. Yeah. Without realizing it, every American will be insured for loss, Every American will unknowingly be our servant. However begrudgingly, the people will become helpless and without any hope for the redemption, and will employ the highest office of the president for our dummy corporation to foment this plot against us. Now on to the evidence. For those we don't have the zoom capability on these cameras. This, folks, right here is a 1963 silver certificate. It's what got JFK killed. This is a modern $5 Federal Reserve note.
Hold on, she's zooming in. Go ahead, hold them up.
Okay.
They look similar.
One says U.S. Treasury, issued by the U.S. Treasury, backed by silver. This one is backed by nothing. And this is what the Federal Reserve System did. Now, talk about devaluation, we're talking 95%. Because if this silver certificate is traded in for 5 pieces of silver, the current approximate fair market value is about $100. Mm-hmm. So if this was redeemed for its real value, which you can't do anymore, by the way, another act of fraud, $5 versus $95. This is the whole agenda. The whole agenda of the world's criminal empire is for one thing and one thing only: control of all of the world's commerce. 10% of every piece of action on the planet, whether legal or illegal. And that moves us into the last 100 years, where things have dramatically changed.
The deconstruction of the American Republic.
Exactly. And offering substitute services and functions. And this is where so many things are such a mess. Now, to move from that, you need to go to the Civil War, because once the Civil War happened, the experiment called the American Republic had come to an end. Okay, compelling the Southerners to adapt those constitutions, specifically the 14th. My opinion, the 14th Amendment in the Federal Constitution is an act of treason. Let me tell you why. All persons born or naturalized in the United States, key word, let's look at what the United States means in the federal code today. Go to Title 28. And I took the time to, as you click through, I copied and pasted each click. Set 5 clicks in. Judiciary. This means the Supreme Court, the appellate courts, Title 28. Particular proceedings. Federal debt collection procedure. Collecting the debt on the interest. Definitions and general provisions. Definitions. United States means a federal corporation. Okay, I wasn't born in Washington, D.C., nor was I naturalized in Washington, D.C. That whole amendment was done to deal with the freedom of the slaves. The 13th Amendment gave them the freedom, but even the Emancipation Proclamation didn't actually free them. That's when they brought the 14th in, thinking that they would somehow resurrect and give them a status. But all they did was make them slave corporate citizens. That's what's being used against us.
Right.
So,
I would like to offer, do we have any time left?
You got 2 minutes. Go.
A couple of comments on this. One, I, in general, agree with you. The particulars are daunting.
right.
One of the things that I often espouse is at the first tenet of our government, and I mean government in New Hampshire, but it was generally of the time pursuant to Locke, is government by consent. The moment the first Southerner was repatriated at the point of a gun, government by consent vanished from the face of the earth.
Exactly.
Done.
And that's just a bald fact.
Right.
We're now laboring, I mean, to the extent that we consent to it now, maybe we do, but it's not the same animal that it was intended to be. Federal Reserve notes. Everybody needs to know that what that $5 Federal Reserve note means is that the government of the United States owes the Federal Reserve $5. And we're trading IOUs.
Plus interest.
Plus interest. Mm-hmm. We're trading IOUs. The scariest thing, if you understand the prime rate, is the recent move of central banks to have to give negative prime rates.
Negative rate, Sam.
And a negative prime rate means that the actual commercial banks do not believe the loans will ever be paid back, and so you have to pay them to take the debt notes.
Yep. And that's what's happening right now.
I know.
Yep.
Well, we said we were going to announce a winner for this debate, so I'm going to announce the winner. The winner is you for watching this show. We're trying to get people to think, and that's all this is about. This is your life, your country, your Constitution. What I'm suggesting to people is you stand up as a man or woman and you claim your sovereign status. Do that with your legislators, all your public officials. Make them toe the mark for you, and let's get our republic back. It's doable.
You
All
guys
right.
familiar with Chris Gronsky?
No,
You need to look him up.
we will. Well, thank you
He-
both.
We're about to log off, and then we'll continue.
Well, thank you both for coming. I really
Well,
appreciate it.
We
If
need to do this more.
if we
I
could
don't think we're on
continue-
opposite sides
No,
of
we're
this
not,
debate.
absolutely, and I wanted, you missed the introduction when you weren't here. I said, listen,
All right, hold
Dan's
on.
not here, and I want to thank Dan, because I wanted to encourage this discourse, because this is what's lacking. This is
Okay.
why the state is a mess.
All right, thank you, gentlemen, for being here. If we can get them back next week, we will. We hope you'll join us. Thank you very much. Have a great week.